No problem from Nigel.
Okay, thank you. Good. Okay, I'm going to minimize this down. I'm probably going to turn my own screen, my own computer video off, so you just see my screen. Okay, minimize that down there. Okay, ladies and gentlemen, well, first of all, thank you very much for coming along to this session this morning. It's literally about sort of 30 minutes. I'm going to take you through where the law stands at the moment and the things you need to do as a business. As part of that, we're going to cover off a little bit about the states as well, because there are some things that people are not entirely aware of. So my name's Philip Allott. I'm a qualified GDPR practitioner. I studied law and graduated many years ago in Leeds. I'm obviously the managing director of Allott and Associates, which some of you will know me from, but I'm also a data protection officer for a number of companies, including a tech company, and I get quite involved with overseas data transfers. Just for those joining us, I'm conscious that people have got, sort of from what you've told me already, varying knowledge. So just a very, very quick sort of resume where we are with data protection law, just getting it in context. Second World War, big issues at the end of the war about protecting human rights. You may well be interested, a group of English lawyers got together in 1949 and agreed that actually it was dreadful that the violations of human rights that happened in mainland Europe. And they came up with what became the European Convention of Human Rights. But at that stage, it was the Council of Europe, and they came along with a number of articles. And one of those articles was Article 8, the right to privacy. So it goes, so if you're moaning about GDPR or UK GDPR, as it now is, blame the English lawyers from the 1940s, because that's where it stemmed from. Various bits of things happened in terms of data protection. Some of you will be familiar, obviously, with the former, which was the Data Protection Act in the UK, 1998. This took European legislation and incorporated it into domestic law. The UK then joined the European Human Rights Act. We became a signature to that, enforced in the domestic courts in 1998. Prior to that, you had to go to Strasbourg, which some of you may well remember reading about. And again, Article 8 is there, the right to privacy. In 2016, EU GDPR was born and became law in 2018. In 2020, December 31st at midnight, the UK formally left the EU in terms of, although we'd left prior in terms of legislation, we were actually completely in sync. And at midnight 2020, UK GDPR became live. Oh, sorry, I'm jumping ahead here. Fine. So just again, just a very, very quick resume. UK GDPR, what's it seek to protect? The personal data concerning any living individual, i.e. people like you, your rights and privileges, including the right to the safeguarding of your personal data, and the protection against the processing of your personal data. And that can be anything from putting it in a metal filing cabinet to storing it digitally or doing something with it that you didn't envisage. It doesn't apply to anything in the public domain, so anything at a company's house, people who put family details on Facebook, and that was one of the reasons that the Privacy Shield fell in the States, because people were harvesting that. But basically, if you put information about your family on Facebook, it's no longer privileged information. And LinkedIn, people obviously put details about their career. So if you choose to share those things on public platforms, don't expect GDPR to protect you. Very quick, again, overview. So examples of personal data, your name, your address, your email address, bank account details, driving license, passport, mobile numbers, CCTV footage. It can even be the IP address of your computer that was held to be private information or personal data. So, GDPR post-Brexit. So, as I intimated there, ladies and gentlemen, United Kingdom obviously left the EU, and we are classified, as far as the EU is concerned, as a third country. Not a third world country, a third country. And that is how the EU views anyone who's not part of the EU. So the UK government is committed to having a robust data protection set of laws. And as we have already highlighted, GDPR is now UK GDPR. But documents do need to reflect that particular change. Now, the driving force behind all this is a piece of legislation in the UK called EU-UK Trade and Cooperation Agreement. And we've done something, it's another kind of fudge. So what we've agreed is that basically we will continue effectively in sync, although we've got UK GDPR, the EU will recognise that for the next 6 months to allow a period for the EU to evaluate whether the United Kingdom meets something called adequacy. So, GDPR is now in domestic law. It's, originally as an EU piece of legislation, it was treated as a regulation, which was read into UK law. But UK GDPR has now been incorporated into domestic law, and it sits alongside the Privacy and Electronic Communications regulations and the Data Protection Act 2018. There are some minor technical amendments to UK GDPR, but the most important thing to remember is it's predominantly the 99 articles of the EU version of GDPR, but it's incorporated into domestic law, and secondly, it applies right across the world. So if we're sending data to or processing data on US subjects or Australian subjects, they're entitled to the same rights and privileges as anyone in the UK or within the EU. So that's the most important thing. Now, as far as the UK is concerned, it's still waiting for a ruling on adequacy from the European Commission, and that means that we meet a certain standard. In terms of the supervisory body in the UK, that continues to be the Information Commissioner's Office, which originally reported to the European Data Protection Board. The European Data Protection Board no longer applies, so it's down to the ICO, which sits under the Department of Culture within the UK. The government has made clear that it is committed here to a very high standard of data protection. And this is the exiting the European Union Data Protection Electronic Comms bill that went through. So, as per where we are, there's very little difference between EU and UK GDPR. So, if you were compliant with EU GDPR, you should be compliant with the UK version. The big deal is this adequacy, and the European Commission needs to decide whether our laws, our data protection laws, provide sufficient adequate protection for data subjects. And basically, they're doing some work at the moment to determine that. And so for the next 6 months, this EU-UK trade and cooperation applies until adequacy is determined. So there's a little bit more here about that adequacy. So it's a test applied by the Commission to determine whether third countries meet the standards. Interestingly, so far, only 12 countries have actually met adequacy outside the EEA. You'll notice EEA, you might think, well, that sounds a bit archaic, but the European Economic Area covers places like Norway, Liechtenstein, and 1 or 2 other places. So they obviously all comply with GDPR. So in terms of adequacy, countries granted adequacy so far are New Zealand, Argentina, Israel, Japan. You might be very surprised about this, ladies and gentlemen, but Venezuela meets the standard, as does Canada. But you'll note on there, the United States and Australia do not meet adequacy. So there is an issue there that has to be addressed, and we'll look at how we address that in a minute or two. So although the UK is anticipating a ruling on adequacy shortly, it's well worth bearing in mind that it took Japan over 2 years to get to the standard that it was recognised by the EU as meeting adequacy. So as per last Friday, a draft decision was published by the European Commission, and it concluded that essentially the UK's version of GDPR was essentially the equivalent to what is in mainland Europe, and that the level of protection was comparable. So it's a draft decision by the Commission. It's now gone off to the European Data Protection Board for their view. So you can see how this bureaucratically strings out. If we do meet adequacy, it's likely to be granted by the Commission for 4 years with a recommendation thereafter it's reviewed. So you can see here that the Commission's looking and see whether there's going to be some convergence and whether we're going to be as tightly knit as we are at the moment on data protection. There's currently no big deal in terms of how we need to send data to the EU and the EEA, and Gibraltar is effectively in sync with the UK. So it's probably just worth covering off what happens if we don't meet adequacy. So for data transfers to be successful within the EU, at the moment, it's fine to transfer data. But if it's ruled we don't meet adequacy, either by the European Data Protection Board or in 4 years' time, you'll only be able to import data containing personal data from the EU if you put in place some special documentation. And there's 2 lots of documentation here. There's binding corporate rules or standard contract clauses. And I'll explain those in a little bit more detail. It's also worth mentioning, and I'm conscious we've got at least one person on this call today from the US, you cannot send personal data to the US legally without putting in place either binding corporate rules or standard contract clauses. And if anybody on this call uses things like MailChimp, you'll see that MailChimp have now incorporated standard contract clauses into their terms and conditions. And that's the case for Microsoft and a number of other big tech players. There's also potentially a need to appoint an EU representative. So you've got 2 things going on here. You've got UK data subjects, and if you're processing data belonging to European subjects, then you've got the EU version of GDPR. And in which case you do need to have a representative looking after your interests both within the EU, don't have to be in a particular country, so it could be in Ireland or wherever, but must be within the EU to uphold data subjects' rights and freedoms. So let's just talk about these in a little bit more detail. So binding corporate rules are designed for companies who need to share data. So I was just chatting to somebody earlier at the beginning of this webinar, and I was talking about India and the need to my clients want to transfer data to India. So you would need to put in place binding corporate rules, and you would need to get the you would need to get the Information Commissioner's Office to sign those off. So you can't just draft them and send them and put them in place. They have to be approved. So these are legally binding. They're enforced by every member in that joint enterprise. And binding corporate rules are basically designed where you have 2 or 3 companies and a head office, for example, in the UK, and wanting data out of the EU, or in the case of the UK, head office here, and maybe we're wanting to pull in data from Europe, or we're wanting to send data for processing outside the UK. So to another company that's owned, it could be a subsidiary, it could be the principal business, doesn't really matter. The point being is if there's some joint share ownership between the 2 enterprises, then you need to use binding corporate rules. That's the rules. These expressively confer enforceable rights on data subjects, which can be enforced in law, and it lays down a structure of how that data should be processed, what rights those data subjects have, and how they actually go around exercising their rights if they're trampled all over. There is a separate department within the ICO, and there's an email address, and I've kindly put that on there for you. So you can actually email the Information Commissioner's Office, the ICO, if you want to discuss any of this. The problem is, if anybody on this call has dealt with the ICO, you'll know that they don't always answer the phone very quickly, and they're not always very good at coming up with the right answers. I say that in a slightly prejudicial way, but that's been my experience. So you can see on there, designed for third countries where you want to share data, including Australia and the United States. Standard contract clauses, often referred to as model contract clauses, are basically for sharing data from the UK where the country or the countries involved, or you may have suppliers in those countries, don't meet something called adequacy. So standard contract clauses, basis for transferring, were originally a basis for transferring personal data outside the European Economic Area. Now in the UK, we have our own version of these, and it just means that if we need to share data, data subjects' rights can be upheld, and it means that you can share data with countries that don't meet EU adequacy, i.e. Australia, the United States, and certain places elsewhere. Again, they offer the same protections as with binding corporate rules. There are effectively 2 or 3 versions of these now. So there's a controller to controller, controller to processor, and I think there's also a processor to sub-processor. Because they're called standard contract clauses, you're not allowed to modify them or change them. Effectively, you put your name on a standard contract clause, your company's name on, and the recipient of the data put their details on. It'll normally be the processor, but may not be the processor, and you date them. And that's effectively it. But you need to show them in terms of documentation. So you put them on your website. You'd incorporate them into your terms and conditions. You may incorporate them into a processing agreement as well, which is fairly standard practice in the UK. Other people say to me, well, okay, Philip, that sounds awfully blinking long-winded. Are there any other ways of sharing data? Depending on the country, we can do something called explicit consent. That means we literally go to, so let's just think as an example, our employees, and we want to use a payroll company because the payroll company is much cheaper overseas. So it could be in America, but it could be in India, for example. So if we need to share data in those countries, we can, if we wish, to get around this and circumvent it, go for something called explicit consent. An explicit consent, as it suggests, somebody signs a piece of paper or sends an email or ticks a box and says, I consent to my data being processed in places like Australia or India that don't meet adequacy. Consent on data processing for people on this call, I think I saw one face who's a DPA, a data protection officer, is problematic because consent has to be freely given, specific and informed and unambiguous. It means it's got to be really clear that it's been freely given and the person wasn't under any duress. This is a real problem for employees because there can be inappropriate pressure applied to them. And also retrospectively, trying to apply these rules is problematic because it means you've got to go around existing employees if you're wanting to share their data, for example, and get consent, and they may withdraw consent. And again, under the GDPR, the issue is you cannot browbeat employees into giving consent because if you do, it's not valid consent. I just want to briefly touch off in terms of the US as well. So the US had the Privacy Shield, and before that, something called Safe Harbor. Last summer, the Privacy Shield fell. There was a court case, which I won't get into too much detail about. It's known as the Shrimps case. And effectively, an Austrian gentleman took Facebook to court and said that the processing of data by Facebook wasn't being properly protected by EU countries. And that case was ultimately upheld by the European Court of Justice. And the European Court of Justice ruled that if you were sharing data with states, the Privacy Shield did not offer adequate protection, and you should therefore use binding corporate rules or standard contract clauses, or indeed consent. It further went on to say in the judgment, which has been airbrushed out to some extent, that it could never be safe transfer using data from Facebook. So in other words, if you put things on Facebook, it's virtually impossible to protect. So it's just worth bearing in mind. So to come back to your businesses, how does this affect you and your companies? So as we touched on earlier on, UK GDPR sits alongside the Data Protection Act 2018, and the UK version of GDPR kicked in at the beginning of this year. So it means that your documentation will need updating. So if you have a privacy policy where it says GDPR, it simply needs UK GDPR inserting. You will also have within that processing agreement, within that privacy policy, a number of things, one of which is overseas transfers. That will need updating as well. Data subjects' rights, it may well say if you are an EU subject, these are your rights. That will need removing, and it will just need your rights because under the UK version, it applies across the world, no matter where the data subject is based. It would be wise also to do a data protection impact assessment in terms of whether it changes anything that you're doing. It's useful to have that on file if the Information Commissioner's Office ever challenged anything you were doing, and all other documentation that you have, including the DPI documents, would need updating where they make reference to EU law. As we've already mentioned, much bigger territorial scope because effectively everybody now has rights. So the first question is, do you own a subsidiary business based in the EU? If the UK does not meet adequacy, there's also going to be issues because you're going to have to put in binding corporate rules or alternatively standard contract clauses. It also has a bearing on data protection officers because if you have a UK data protection officer, you need to make available a data protection officer who's accessible within, for example, the EU and rest of the world. You can use the same person, but they have to be easily accessible. So if somebody emails you in French, then you've got to be able to reply back in French. So just to go back to that ruling for adequacy, at the moment we don't know that ruling, but 11 of 12 countries which are classified as third countries that the EU recognises as having adequacy has told the UK government that they will maintain unrestricted personal data flows with the UK. So Japan's an example of that. There's currently no change in the way the way UK businesses will send personal data to other countries deemed adequate by the EU and Gibraltar. What you now need to do then is monitor over the next few weeks whether the UK is deemed as meeting adequacy. And there's a website on here, and I'm going to share this with you after today, which will probably be on Monday. And you should also be preparing a plan for updating any original GDPR documentation to reflect UK GDPR. You need to check whether you import any personal data from Europe to see if any further safeguards are needed. I would also recommend that you have a look at the government's website and monitor what the UK government is publishing sort of after Brexit, which there are little nuggets going into there as well. Okay, ladies and gentlemen, a very sort of quick overview in terms of where we are. I'd be very pleased to pick up any questions that anyone has that they may want to ask. Hello, Ruth.
Hello, Philip. Hello.
I'm good, thank you. Yourself?
Yes, I'm very well, thank you. Can I just say how much I enjoyed that presentation? And it was really crystal clear, and I could digest all of it. Internally, obviously, of course, I've got a little bit of panic because I need to bring the rest of the business with me on this plan for updating our documentation. If needs be, Philip, do you offer a service where you can support businesses if we become unstuck?
Yes, of course. So we do two things really. You can, or three things. So you can fob the whole lot off to us, and we'll sort it for you. It's a turnkey solution. You can buy consultancy from us, and we'll look and we can do an audit to see where you are. Or alternatively, you can come back and say, look, we're struggling with this document here. Can you take that away and just sort it out and make it sing and dance? And we'll do that for you as well. We're insured up to £5 million on this stuff, so you're in fairly safe hands.
Oh, I know we'd be in safe hands, Philip. That's really great to know. So watch this space.
Okay.
I think because I look after marketing, and from a marketing perspective, I think I'm on it. But of course, I come from a small business, and there are other parts of the business because we trade all over the world and sell online courses, and I think we'll need your help.
All right, perfect. But, thank you.
I'll be in touch. I won't steal all of the time. I'm sure other people have got questions.
Good. Has anybody else any further questions? Deadly silence. I put them all to sleep, Ruth, though. I'm not sure if it was...
Yeah, I have a question. Can you define processing?
Processing, yes. So processing is anything that you actually do to personal data. So as an example, that could be simply putting something in a filing cabinet. I came across an osteopath who was actually, she thought that if she didn't put anything on a computer, she wouldn't be doing any processing. So she actually took her patient records, put them in a wooden box, and put them under a bed on the basis that there wasn't any processing going on. Unfortunately, putting them in the wooden box actually is processing. Obviously, storing things on computers, even if you're not doing anything to them, is processing. And other examples of processing is obviously where you have Outlook and you store people's contact details in there. That is an element of processing. And under GDPR, which is a bit different to how it used to be under the Data Protection Act, you have certain duties, which is called the CIA, which is confidentiality, the integrity, and the availability. So keeping this stuff confidential is 1/3 of it. The integrity of it is that you keep the records together, you don't go lose the records, and available means that you can't actually make them available if required. So you've got a responsibility to keep the integrity, so you think of backups, and then the availability, so you've got a service there that if somebody says, I want to do a data subject access request, you can make that available. So anything that's got personal data in there of any description, generally UK GDPR applies to. There are odd exceptions, but they're very unusual. Things to do with domestic servants, as an example.
So if you have a membership organization or the members list are stored on a computer and they're stored even in the UK on a server, and somebody is outside the UK but needs to help with one particular member and actually views the data, wouldn't necessarily transfer it, but look at it just so that they can give some advice, how would that work? Would that be okay if the server was secure and the data was, under UK control?
So effectively, you're transferring electronically the data to, for example, the States. So although you're members of the same organization, you're accessing in the States data belonging to UK subjects. There is a fundamental problem with this. Under the Homeland and Defence Act in the States, anybody based in America, and certainly American corporates, have a duty to make available to the federal government on request any information they have access to. So you can imagine this is a real problem for airlines like British Airways or BA and other people. So if they have American based employees, those employees have a duty to share that data with the federal government. So you need to put in place some safety mechanisms for sharing data. So if you're part of the same organisation, I would look at binding corporate rules or consent. If you're not, then you would look at standard contract clauses.
Yeah, I think I understand that. So what I'm looking at is there's a person that is working for the organisation in the UK and travels somewhere out of the UK, could be within any of the countries, but is just looking. They're not actually moving data, not storing data locally, they're viewing data so they can make a suggestion about maybe a particular member wants to change their status within the organisation. Is that still being processed offshore because that person's traveling for business?
So if they were logging on to the network and it was a secure network, and that's always a big question, and the server was based in the UK, we could well argue that the processing was taking place in the UK. You'd really need to do a data protection impact assessment to determine that. But in theory, you could well argue that that was the case. Conversely, depending how the processing went on, you could argue that that data was actually temporarily getting transferred to the US because you were effectively accessing it in the States. It's too tight to call, in all honesty, but I would do a data protection impact assessment to document that in terms of that data flow, I think, as a starting point.
And how involved is that on, say, a line item like that, just out of curiosity?
How involved in what context? So you mean the time effort? Or?
GDPR, the data protection impact statement on a line item like that, is that a very involved process? Or?
No, not necessarily. I mean, something like that, there's probably about 3/4 of a day's work to properly document it, maybe half a day's work, but it depends if it digs up any real anomalies, really, because it will probably come back with it's twofold, really. There's going to be an issue in terms of what's been shared and whether it's adequately protected. And then if it's not adequately protected, what needs to be put in place in terms of safeguards to make sure it can be adequately protected.
Got it. Thank you.
You're welcome, Nigel. Good. Does anybody else have any further questions? You're all very quiet. Good. Okay. Well, unless anybody else has any questions, we'll end today's session. Thank you ever so much for participating. I will let you have this. It's been recorded as a video. So we'll send you this as a video. So it'll show the video and it'll show the slides as well. And it'll probably pick up the questions as well.
Thank you, Philip. That was superb.
Thank you very much, Ruth. You're most kind. I didn't plant, by the way. I didn't plant Ruth, by the way, in the audience to say these things. She's volunteered them, but it's lovely to see her. She's one of our clients based in Wales, and she always says the nicest things.
Oh, it's all genuine. It's all genuine. Thank you, Philip. I really enjoyed it.
Perfect. Thank you ever so much, guys. Okay, cheers. Bye.
Thank you. Bye-bye.
Bye.
Bye-bye. Thank you.
You're welcome. Bye.